Hi, welcome back, and Merry Christmas and Happy New Year. We've got another holiday hypothetical for you to consider. So, a lot of companies around this time of year decide to have a holiday party. So, let's imagine that a business decides to have a New Year's Eve party. New Year's is on, middle of the week, and they say, "Hey, we're all meeting. We're having a party. We're gonna have music. We're gonna have drinks. We're gonna have food, and it's heavily indicated that you should go." And then you're at this party, having fun, you're dancing, somebody bumps you, slip and fall, and you tear a muscle in your knee. This is a holiday party, so no work's being done, nobody's on their computer, no one's sending fun emails. Is this a workers' comp claim?
If I am the employer that is throwing the party, I might be kind of annoyed, but I would argue that it is a compensable workers' comp claim.
All right, so why? Because my instinct as the employee is this is a party, this is not related. So that's my instinct. Is your concern, do you think, worry as an employer or worry as an attorney?
I mean, I'm thinking as an attorney. So we're looking at it, we got to look at it. It's arising out of employment and the course of employment, and arising out of, it considers the time, place, and circumstances of where the injury occurred or when it occurred. And then in the course of, considers essentially the Lord v. Daugherty factors, which are a control, benefit, PCB, proximity, control, and benefit to the workplace, etc. And so that's where we're going to analyze the thing. And those factors, it's not like you have to have them all in equal measure. One may be more persuasive than the other. So that's how we're going to look at it. But we also have case law.
Okay.
Right? And so I could put the case in the show notes because I don't know how the case on the top of my head. But for example, they have a case where somebody is their teacher, they're buying flowers, and they're using money from the flower purchase fund. This is a case in Ohio from the flower purchase fund. So they work at school A and they're going to school B to buy the flowers or deliver the money. I can't remember which, but in any case, whilst walking to school B, which is not where they work,
Yeah.
they end up tripping, getting an injury. And so they do that analysis and then they say, and so in that instance, they're really looking at that proximity control benefit situation. They're looking heavily at the benefit. And the court said, hey, it's good for rapport and esprit de corps of the employees, this flower benefit fund. So we're going to say they're...
Yeah, I think the rapport thing, the community building, team building, that's going to be the main factor, I think, that gets hammered in. Is this is the end of the year celebration of what? Of the work, of the job itself. And then, to stay together, have fun, all leading into the next year, and hopefully that's going to be why this is a benefit to the employer.
And it's an employer sanctioned party. Now we could anyways, let's finish this, but I'm going to twist it.
Yeah.
So.
What do you mean?
Oh, okay. So what I was going to say is, and by the way, where's this party being held?
Well, that's what I was going to say. I think that might be one of the issues. If it's in the building where it is, you just clear out desks, you're having it there, I think the employer might be out of luck. But what if you're going to a restaurant downtown? So you've never been there before, name's not on the building, you don't know these waiters, I think this might be enough of a recreational activity that is it sanctioned or is it just encouraged?
Well, again, and that's the other twist. So you have multiple twists. Let's tackle the first one. If it's in the building, like we're in our office, again, we're looking at proximity control benefit. Proximity, it's right within the building, and control even comes into play because we control the space. The employer controls the space. So those three factors are very heavily in favor of being a compensable workers' comp claim. Now, if it's off-site, I have no control over the restaurant.
Right.
What's the Beacon Barrel or whatever, one of these other fancy restaurants. I have no control of that place. Proximity, I mean, it could be 20 miles away, 10 miles away. Proximity might not be that close, so that might not be great. But I think still the benefit, if it's a employer sanctioned, like if I'm paying for this, I think that really leans heavily being in a workers' comp claim. But again, the benefit, the esprit de corps, or the rapport, or the friendship making, trying to make the team more of a team, I think that leads heavily in favor of being a workers' comp claim.
So a factor that I wonder about, and I always think about this if I'm arguing it in the room. and is, let's say it's a company of 50 people, only 25 people go to the event. Does that make it less of a company event? Whereas if everybody goes, or 48 people go of the 50, do you think that's a factor, or is that irrelevant?
I mean, I think it's a factor, and it's probably a lame party. Not everybody went, but but no, I don't think that would at least I don't think that would be a big issue in whether or not it's a workers' comp claim. But like, what if it's a terrible party and like of the 100 people in the company, like 3 people show up? I think the issue is it am I sanctioning it as the employer, and am I paying for whatever horrible party this is that it's so bad?
So another thing employers like to point out is something being optional. For instance, I don't have the option to not work during the day. My job duties are my job duties. Obviously I get paid for it, but it's still, that's not an option. Going to a party presumably is an option. Do you think that people having the ability to opt out will be held against them because they chose to be there?
Yeah, so like, this is an after work party, after hours, and we'll have that. Employers will be like, well, this was after hours, whatever. And I've never encountered a party injury, but
no,
but we've encountered other circumstances, and they're like, well, this was, they were going over here, or they're going to Cedar Point or whatever, and this was out of hours, this is on the weekend. I still think, I mean, that's certainly an argument that I would make if I was an employer's attorney, but I still think the benefit thing would be heavily in favor.
Now, I would say if this is during hours, if this is at lunchtime, everybody's on the clock, I think the employer's out of luck. I think this is considered a work event, a work duty, or whatever, if you're on the clock while this happens. If this is a lunchtime party and everybody's being paid, I think this is a valid claim.
Yeah, but weird things happen, and I've made a short where somebody had filed a claim where they're in the lunchroom of their cafeteria and they tripped and they denied it, and I think they said it was a purely personal type, which
right.
is a terrible decision, by the way.
Yeah, I agree, but
yeah.
I think there's a difference though between, hey, we all went out to lunch versus this is our holiday party.
So let me spin it and make it not a compensable claim.
Okay.
So you and JD and Yanaris and the other people in the office decide to hold a Christmas party at Schmidt's. Okay. And then you choke on whatever, or you get in a car accident going to Schmidt's and you file a compensable claim. Is that, and I have no part of this as an employer. I didn't pay for this. I didn't organize it. I might not even known about it. So then what's
that's just bad timing. You're with coworkers, you're not at work. They just happen to be a witness to a personal event.
Yeah, and like if you, and it could be everybody, and I would argue, so using your example of the numbers, so let's spin it, let's say you have 100 people in the company, and everybody, you guys hate your boss for some reason, and your boss is just clueless, and you all organize this party after hours outside somewhere, but you have basically 100% of employees going to it, and you get injured, at some restaurant or dance hall or whatever kind of situation.
Yeah, I think that's an interesting spin. I still think the employer is going to win that one. If it's not sanctioned, it's not with their notice. Where it'd be trickier is if the employer knows and just kind of turns a blind eye. Then you might be able to say, like, if this party's happened every year for decades, then the employer that might be like an almost approved company party. But again, that's where things are getting real murky.
What if it's in the office?
In the office?
And it's not sanctioned and your boss has no awareness of it, but you guys throw a party after hours, everybody's clocked out, and somebody gets injured.
That's good.
It's a weird one.
That's weird. I think that's going to be hearing officer dependent.
Right.
I think once that goes to court, I think you're out of luck.
Because the employer controls the place. Obviously, they're not really. I mean, they can make an argument they're not controlling it after hours, but controls the place. Benefit, again, a esprit de corps type situation. Proximity, it's there. That's a weird one, dude.
It is.
That's like the water jug thing. I'd be kind of pissed if I was that employer.
Yeah.
Especially if that claim got allowed.
Right.
Like the unsanctioned party.
Yeah. Okay, so are employers able to waive these? They say, hey, we have a party. We want you to feel welcome to go, but
But we don't want any responsibility.
But we don't want any responsibility, right? Is that allowed?
Yes, it is allowed.
Okay. Yeah. Obviously, I already know this answer because I've got the sheet in front of me. So there is a. Let's see. If you want to look this up for those of you that are real fun, it's called a C-159, BWC C-159. So we got a waiver here. It's called the Waiver of Workers' Compensation Benefits for an Employer-Sponsored Recreation or Fitness Activity. We don't see this a ton. We actually had to read it before we started the video to make sure we had this right. Usually where I see this, though, is the, hey, at lunchtime we're going to have a three-legged race. This will be fun. Maybe you bring your kids or whatever. But they don't want people getting hurt doing a three-legged race. So they might have them say this, hey, you're more than welcome to do this. It'll be fun. I think it'll be team building. But if you get hurt, we're not a three-legged race company. So you're going to fill this out. And
I just think it's funny that, like, these forms get developed for reasons. And they're like, oh, we're really concerned about this. So they came up with this waiver form.
Right.
And it's backed by, it's in the statute as well. I mean, that's where these things come from.
Right, and it specifies on here that you're waiving your rights to compensation and benefits under the Ohio Revised Code for any injury or occupational disease while I voluntarily participate in the above activity. And it has you put that in there. What's your name? What's your employer name? What's the specific event? If they're making you fill this out, I'm not saying you need to be concerned that you're about to get injured, but you should know that you're on your own.
Yeah, you're waiving your rights. But so it says a specific, lists the specific dates. I wonder if, like, an employer could use this as, like, a means to, like, not cover people. I wonder if anybody has. That's the funny thing.
So we had a claim a few years ago where an employer had an on-site workout center, weights and everything.
Yeah.
So they had them sign a waiver saying, you're going in here voluntarily. We went to hearings for this, and we won. This was deemed a valid claim because the waiver they signed was not this. It was a general waiver, and that general waiver did not specify that you were waiving workers' compensation coverage, and 2 different hearing officers upheld the decision. And
I think that was you.
Yeah, that was me.
Pat on the back to great.
Yeah, we won that because it was not a workers' comp waiver, where this specifically is a workers' comp waiver.
See, that's why you need a workers' comp attorney, either if you're a claimant or an employer.
Right. And I think where you think they might get tricky, if you have me fill out here that me sending emails, I'm waiving, that's a lot of what my job is sending and receiving emails. Yeah. I think this is getting thrown out.
I just think it's funny.
Because that is my job. If I break a finger on an old keyboard, I think Mr. Malek's out of luck. Even if I wrote on here that I'm waiving, because you can't waive, you just in general can't waive your all workers' comp rights. Because every employer in Ohio would have you waive all of your rights as a condition of employment. So
we can move in that direction.
Yeah. If we're not lucky, that's where we're going. Yeah. So ultimately, I do think. I don't know. I think the employer's going to have a lot of room to argue here if you get hurt at a company party off grounds, and I think that's probably going to be what it's deemed as. Is this in the office? Especially if this is on the clock. This is a work injury. It doesn't matter. You're not sending emails. But if this is after hours, voluntary, outside the office, I think that you basically got hurt doing something fun.
Yeah, agreed. As we say at the end of all these videos, this stuff, workers' comp, is incredibly complicated, and as you can see. So we always recommend ask your friends, neighbors, doctors, coworkers, etc. Who do they use for their workers' comp claim? Look at Google, whatever. But talk to an attorney, talk to multiple attorneys. Find the attorney that you like, because it's going to be hard to switch.
Yeah.
But get somebody involved, at least present them with your issue. Also, one other thing really is, folks, we're almost at 300 subscribers for workers' comp YouTube. Please subscribe, just for my own edification.
Yeah, the norm, like and subscribe. And for my own, because I don't care how many subscribers, is if you have questions, if you have a scenario, if you say, hey, this may not be real, but what if this happened? We'll talk about it. Anything that people muse about, if whether holiday related or not, if you're like, well, I want to know what would happen here, just write us a comment.
Yeah.
We'll read it, and maybe that'll be our next video.
Yeah, and I'll try to analyze it and give you a coherent response. So.
All right. Well, that's what we had for you today. Hope you all had a nice Christmas. You have a nice and safe New Year. If your company's throwing a party, I hope you go. I hope you have fun. But I hope you also don't get injured because you might be out of luck. So I hope you guys all have a nice New Year and a nice safe New Year in 2026. Thank you.